as you've made it, you'll know that we're here to discuss the case of Pakistan International Airline Corporation and Times Travel UK Limited, in which all of the panellists today were instructed before the Supreme Court and on which we await judgment. I note, although unfortunately he cannot make it today, our leader there was Thomas Rowe, Queen's Counsel, and our appearance was in support of the intervention of the all Parliamentary Party Group, Fair Business Banking. The batting order, as it were, is as follows. I'll start off by giving a brief refresher to the topic and to the facts of the appeal before passing over to my colleague Hannah Fry, and she's going to take us through the position of the lower courts, before in turn passing over to, for my money anyway, the most mellifluous voice at the bar, and Richard Samuel, Senior Junior for the all-party group. And he's going to lead us through what were the issues before their Lordships, before the Supremes, and take us on a dive into them. If any questions do arise during the course of the discussions, I would invite you please to type any questions you have into the chat box, and we will come to them before the end of the day. So bringing the guillotine down, as it were, on the introduction, the appeal was about economic duress, and as of course is well known to you, it is well established that a contract may be avoided on such grounds. That's why, for example, in the 1979 decision of North Ocean Shipping and Hyundai Construction, the shipbuilder's threat to terminate a contract for the construction of a ship without legal justification, unless the price was increased by 10%, was held to amount to economic duress. Why? Well, the court held there that the purchaser, who critically had already chartered out the vessel in advance of its completion, had no choice but to accept the shipbuilder's illegitimate demand, and therefore the purchaser had the option to void the contract. But despite this waypoint, and despite others like it appearing along the way, the law remained relatively uncharted, and as such the doctrine actually has remained fairly uncertain. Enter the appeal. And the appeal concerns perhaps the area of the greatest uncertainty, that of lawful act duress, and the question of the status of a contract that results from the threat of a lawful act or omission. Does lawful act duress exist at all? And if so, in what circumstances might it be invoked? That brings us to the facts. PIA, and that's what we're going to call the airline, it is a major provider of flights between the United Kingdom and Pakistan, while Times Travel is a travel agency whose business was primarily dependent on its ability to sell tickets for PIA's flights and to do so within the local community in Birmingham. Now, that relationship was not always happy, and there had in fact been disputes between PIA, Times Travel, and in fact other agents, considering the level of commission that was to be paid for the services provided in the commercial relationship. But it was only really in September 2012 that the crucible moment was reached. For it was then that PIA gave notice of termination of all existing agency contracts in accordance with their terms and offered new ones in their place. However, this new offer was only on the terms that the agents waived their pre-existing claims. The upshot of all of this was that not all of the agents succumbed to the pressure, and they continued their proceedings, while some agents took a different approach and successfully bargained for a term in the new contracts that entitled them to receive from PIA a sum that was equivalent to recoveries made in the litigation, as if they had brought or continued their proceedings. But some took a different approach still, and Times Travel in fact accepted the terms that had been offered by PIA only in 2014 to bring proceedings to recover the commission, as well as other payments which it was said were due under the earlier agreements. And that is ultimately how the APPG ended up intervening in the Supreme Court. So with that, and doing my best to forswear a pun about reaching cruising altitude, I'll hand over to my colleague, Hare.
Many thanks, Daniel. I'm going to give you a quick overview of the decisions of the Court at first instance and the Court of Appeal in this case. The first instance decision was handed down by Justice Warren on the 14th of June 2017, who held that economic duress had been established. He held that although PIAC acted lawfully, the airline had placed illegitimate pressure on Times Travel. There had been no adequate notice period. Times Travel would have been forced out of business if it could not sell PIAC's tickets, and Times Travel's business could not have survived if the ticket reduction continued for much longer. The effect of this was that Times Travel had no practical alternative but to accept the terms of the new agreement. Therefore, as a result of PIAC's actions, Times Travel entered into the new agreement under economic duress. And of particular note is that a finding was made at first instance that Times Travel had not established bad faith on the part of PIAC. And that becomes particularly relevant when looking at the Court of Appeal's decision in this case. The Court of Appeal gave judgment on the 14th of May 2019, with Lord Justice Richards giving the majority of the court's decision, and found that there was no economic duress. The critical issue was framed as whether, in a commercial context, economic duress could arise where a party carried out lawful acts in support of a demand which it believed in good faith it was entitled to make. Lord Justice Richard referred to the Court of Appeal case of CTN Cash and Carry v Gallagher from 1994, and that hadn't been referred to by the lower court. He stated that in his view, CTN can be taken to establish that where Party A used lawful pressure to induce Party B to concede a demand to which Party A did not in good faith believe itself to be entitled, then Party B's agreement would be voidable for economic duress. Also, it was found that there was little or no support in either the academic literature or the authorities for an extension of lawful act duress to demands made pursuant to belief that was genuinely but unreasonably held. In conclusion, the Court of Appeal's decision meant that economic duress does not extend to the use of lawful pressure to achieve a result if the party exerting the pressure believes it in good faith it is entitled to do so, completely irrespective of whether objectively there are unreasonable grounds for that belief. It was held that there was no reason why the common law should hold that a party with a private law right, whose exercise was not subject to an overriding duty, could not use that right to achieve a lawful purpose in good faith. Applying this reasoning to the instant case, economic duress was found not to be established. PIAC was held to have a genuine belief that it was entitled to reject Times Travel's claims, and it had not acted in bad faith. And in Lord Justice Richard's view, a lack of reasonable grounds is insufficient to engage the doctrine of duress, where pressure involves the commission or threat of lawful acts. And with that brief overview, I'll now hand over to Richard for an in-depth discussion on the Court of Appeal's reasoning and the issues on appeal to the Supreme Court.
Thank you both. Thank you, Hannah. What I intend to do is to try to distill the essence of the relevant parties' cases before the Lordships, so that we can take some idea, or what are very detailed submissions, of course, so we can get some idea of how the judgment may turn out when we get there. I say the relevant parties because there were, in fact, a number of interveners, of which we were one. But we'll start with the parties themselves. And it was, of course, Times Travel who appealed. And the appellant's case was, I think it's fair to say, an ambitious one. It was in essence saying that a judge is entitled simply to look at the equities of any in particular case in deciding whether there's been duress or not. And we should abandon rules of law which constrain the discretion of the judge to decide whether a contract should be defeated because it was entered into under duress. And it followed from that that they argued that we should abolish the distinction between lawful act and unlawful act and simply let the judge decide whether the pressure that was brought to bear was morally or socially acceptable. So a very broad argument sweeping aside effectively the distinction between lawful act and unlawful act duress, and on the basis that these rules of law create injustice. Now, in order to advance that argument, they relied very heavily on the 2016 decision of the Supreme Court in Patel and Mirza on the doctrine of illegality in contracts. There might in fact be, because leading counsel for the appellant in fact appeared in that case before their lordships with some success. And indeed, the success was little more than a revolution in the law of illegality. It shifted the law controversially from rules of law being strictly applied to instances of illegality, rendering contracts void, to this range of factors test, which the majority of the Supreme Court adopted in that case, and where that range of factors approach effectively gave the judge a discretion, if you want to call it that, as to whether to declare a contract void where it was tainted by illegality. And whether he does so is dependent on that range of factors test, which gives effect to the equities of any particular case. Now, as you'll know, presumably from that case, the Patel and Mirza was decided against the background of a body of very controversial law which had been built up over a long time about rules of law which give rise to illegality, in particular Tinsley and Milligan in 1994, and the Law Commission suggesting the revolution, which in fact happened in Patel and Mirza, and a judicial schism, as Lord Sumption called it in that case, about whether it was a good thing to abandon traditional rules of law and apply the range of factors test that they did in fact apply. And indeed, the lead judgment in Patel and Mirza was given by Lord Toulson, who was the Law Commissioner at the time that the Law Commission produced its report on illegality. So that was a very particular set of facts. In fact, that judgment is still controversial. Patel and Mirza, no less than the Chancellor of the High Court, Lord Justice Voss, gave a speech criticising it while still in office. And in my view, the argument of the appellant is somewhat ambitious because those factors are absent in the question of lawful act duress. We don't have a judicial schism. There isn't a controversial body of case law. We don't have a law commissioner on the panel of the Supreme Court. Instead, what we have is a series of authorities which have developed since economic duress was recognized in the 1970s, which effectively hold open the door for lawful act duress. But there aren't any cases which have been decided clearly and expressly on the basis of lawful act duress. Nevertheless, the appellant has a foothold in the authorities to advance its argument because those authorities that there are consistently have chosen the formulation to hold the door open, which is based upon a bargain being obtained by illegitimate pressure. And they've chosen that word or that phrase rather than unlawful pressure. And it's really that toehold which the appellant was the springboard from which the appellant was able to advance its arguments on the basis that if they meant unlawful, they would have said unlawful. They didn't. They chose not to. They said illegitimate because they were conceiving of the illegitimate pressure being a more open textured test than simply the strict application of the rule of law as to whether a threat was illegal or not. I think it can also be said that there's something of a distinction between illegality and lawful act duress, and that's this. Whether an act is lawful or not, or sorry, illegal or not, is dependent upon the application of the rules of criminal law. So if you like, there's a jurisdictional threshold question as to whether a contract has been tainted by illegality or not. The next question is then, should it be void for illegality? And it's at that stage that Mirza creates and effectively creates the judicial discretion, the controversial judicial discretion, as to whether the contract should be enforceable or it should be void. That stands in contradistinction to duress, where there's only one question, and that's whether the pressure was legitimate or illegitimate. So the jurisdictional and discretion questions are fused in one into a single question. You don't have that jurisdictional filter. So the analogy with illegality is perhaps somewhat imperfect, but there it is. That's how the appellant put its case. The respondent had an equally ambitious case in my view. It's that lawful act duress simply didn't exist. You thought it might have done, but it doesn't. Only unlawful act duress exists. They said, look, it's true that the cases do hold the door open for illegitimate pressure, which encompasses something more than unlawful, and therefore by implication, lawful act duress. But the courts have never actually walked through that door and decided a case properly on that basis. And now is the moment to slam it shut so that everybody's clear that there is only unlawful act duress. And they say that's the right answer because it's supported by policy reasons, the uncertainty that would be created by leaving the door open, and the logical inconsistency of deciding cases based on these open-textured subjective considerations about somebody's state of mind, which creeps into the area of illegitimacy. And judges shouldn't be in the business of deciding morality. They should be in the business of deciding legality. So, on the contrary, they say, if it's lawful, anything goes. The only thing is that it has to be lawful. If it's not lawful, the contract is defeasible at the option of the threatenee, if I can put it that way. Now, those are the sort of polar opposite, stark choices, which were being offered by the parties to the case. It's probably worth mentioning that there are two concepts which really sat at the heart of the submissions on either side, or at least the arguments as they swirled around. The first is good faith. And as you've heard from Hannah, the Court of Appeal decided that when one deals with lawful act duress, then as a matter of law, it's a necessary ingredient that there be bad faith on the part of the threatenor. On the facts of this case, as the first instance judge decided, the respondent genuinely believed in his right to make the threat and to make the demand, and that he did on the back of the threat. So in this case, on the facts, the particular contract was not voidable, but the ratio was, if you move beyond unlawful act duress, the doctrine only bites where the threatenor acts in bad faith. Well, the respective parties' position on that particular part of the ratio is as follows. The appellant said, well, good faith is important, but it's just one of a range of factors, like all the others, that the court must take into account. Therefore, the Court of Appeal is wrong. The respondent said, well, the Court of Appeal is wrong because good faith is irrelevant, because we're only dealing with the lawfulness, and good faith has nothing to do with the lawfulness concerned. And anyway, it's unprincipled to decide cases based on the threatened law's subjective intention when it's the work of the courts to apply objective principles of interpretation to contracts. So that's how they stood up there. Neither of them supported the Court of Appeal's position. The other concept which was floating around came as a result of obiter comments from Lord Justice Leggett deciding a case at first instance, Al Nahayan and Kent in 2018, where he observed, although it's strictly obiter, he came up with a formulation which is being characterized as objective bad faith, which a lot of people have thought to be a terribly useful concept in unlocking the complexities of this area. And so he said this: a demand coupled with a threat to commit an lawful act should be regarded as illegitimate if the defendant has no reasonable grounds for making the demand, and the threat would not be considered by reasonable and honest people to be a proper means of reinforcing the demand. Now, so that's floating around there as a helpful obiter dictum. What were the parties' positions on that? The appellant said, that's fine, but it's just an example of judges deciding cases on the equities. So there's no magic in that formulation. The respondent said, well, criminal blackmail, so in fact, which is formulated under Section 21 of the Theft Act, 1968, is an example of unlawful act duress. And that is something which the courts should, of course, recognize. But objective blackmail, this creation of Lord Justice Leggett, is unprincipled because it effectively reignites some pre-1968 law on blackmail, which was contained in Section 29(1) of the Larceny Act 1916, which applied an objective test back in those days. And it's unsupported by authority. Don't go there. So neither of the parties supported that position either. So at the moment, very polarized argument. What about the other interveners? This arose from the case of Ukraine and Debenture Trust, which is a case which is still before the Supreme Court. They were invited by the Supreme Court to make submissions on this case because their case arose out of a threat to invade, Russia's threat to invade Ukraine in a bond dispute. And they lined up in really a very similar fashion. The appellant, Ukraine, who were the threatenee in that case, tracked the appellant's submissions in this. They basically said, well, look, it's not possible to say that lawful act duress doesn't exist. It's there in the authorities. You can't just kill it. It's unprincipled to just slam the door in the way that the parties, the respondents are inviting you to do so. Recognize its existence and simply decide the case on the equities. The other intervener, the Debenture Trust on behalf of Russia, tracked the respondent's submissions. Lawful act duress is not being applied in the authorities. Don't suddenly start applying it now. It's uncertain and it's unprincipled. And then we come to us, the intervener for the all-party parliamentary group on fair business banking. What are we doing there? We are there because this parliamentary group has formed around an idea of a proposal I made, in fact, back in 2013, to create a tribunal for the resolution of disputes between banks and their small business customers because they weren't able to achieve it elsewhere, which got this group of MPs excited. And they have been looking at areas which they think have an impact on small businesses. They find that small businesses are often forced to compromise claims that they have against banks on the threat of foreclosure, lawful threat of foreclosure of the loans and the mortgages and the securities which underpin the facilities that they trade under. So they find themselves, they say, in a very similar position. So what position did we take as an APPG intervener, making an application to intervene rather than being invited to do so by the Supreme Court? We sought to find a middle ground between these polarized positions. We supported the idea that good faith works, it helps as a way to cut through the complexities of this. And we slightly rode two horses, or kept our options open about whether it was a formal element of the of a defense of duress, or that it was simply an important factor in a range of factors approach, which are the two possibilities. But our big point was that everybody had missed, including the Court of Appeal, that good faith is to be determined objectively. It is not to be determined subjectively by the belief, the personal belief of the person making the threat or making the demand. That's not the ultimate test. But the mistake that both Mr. Justice Warren and the Court of Appeal made is they did apply the subjective belief of the threatenor as the touchstone by which good faith needs to be decided. Because of his personal belief that he was entitled to do those things, he did in good faith. Now, we say that's an error of law. And that is the basis upon which we were granted the right to intervene. And that raises the question of what good faith is. And the way that we formulated it is to say that it is honesty plus, if you see what I mean, which is that there is a core of honesty, a core concept of honesty within behavior, good faith behavior. But it's more than just honesty. It's honesty plus a set of behaviors which are somehow considered appropriate in the circumstances, proper, one might say, if indeed one borrows from the law of blackmail. That is a word that you find as a potential defense to that action. And there are a number of cases which support the concept of an objective concept of honesty plus a little bit more. Yam Seng, that was Mr. Justice Leggett in 2013 at first instance. Bates and Post Office, Mr. Justice Fraser in 2019. New Balance Athletics, Mr. Justice Tier in 2019, and Essex County Council and UBB Waste, which is Mr. Justice Pepperell in 2020. There are others, but those are the core authorities establishing that honesty has roughly those characteristics. And the significance of that is this, that we know as a result of Ivey and Genting, which has endorsed the line of case law which began with Royal, Brunei and Tan in the Privy Council back in the 1990s, that honesty is not to be decided subjectively, it is to be decided objectively. That is to say, you look at the subjective beliefs and the subjective understanding of the facts available to the individual concerned. You will consider his belief and the facts that he was aware of, but the ultimate test is whether ordinary, decent people would consider his behavior honest or not, which is an objective standard. And that objective standard should be applied in the same way to the propriety element of good faith as well. But it's not possible to admit of a concept of honesty inhabiting good faith and consistently with Ivey say that it is subjective. It's not, it's objective. That much we know. So if it is objective rather than subjective, which everybody else was saying it was, then the force of the arguments of the respondent and the appellant tend to fall away. It's not unprincipled, as the respondent says, to look to objective concepts of honesty and good faith in the way that it would be to look at the subjective state of mind of an individual when you're considering the enforceability of contract. It's not unrealistic as a standard to meet, as the appellant says, to say that it's defeasible where good faith is met in the same way that it would be if it were subjective, because of the difficulties of persuading anybody, as Ivey says, persuading anybody to a court that somebody didn't genuinely believe what he said he believed, rather than simply applying an objective standard to it. So we said, it was a workable and useful threshold question, if I can put it that way, which strikes a balance between helping prevent uncertainty or preventing uncertainty and providing an anchor for the equities which are otherwise floating around and are no more precise than the range of reasonable responses test, or the range of factors test, I should say, in Patel and Mirza. Now, there are difficulties with the analysis. How does good faith intrude in a negotiation, which is an adversarial exercise where parties don't owe duties to each other, particularly of good faith? We know that there's no duty of good faith in that situation, but we say that that difficulty can be overcome because there's a difference between having a duty of good faith to each other and from acting in bad faith or an act of bad faith as opposed to the other. And one gets to that conclusion by drawing, for example, from the law of misrepresentation. You're not under duty to be honest, but if you misrepresent something, then that will mean that the contract is defeasible. Now, 532, that leads me on to the final elements of this, which is blackmail, which I'll say something a little bit about if I have the time, unless my colleagues are going to close me down for running over. But the concept, perhaps I can say a little bit more about that in the time available. Do we think that the Supreme Court is going to adopt Lord Justice Legate's objective blackmail test as a touchstone for lawful act duress? Indeed, he's on the Supreme Court now, but he wasn't on the panel deciding this particular case. No one argued for the test. Each side simply said that blackmail supported their particular point of view, but it remained front and center. Personally, I suspect that the analogy has its limits. Blackmail by its nature, the focus is primarily on the demand. An unwarranted demand with menaces is the classical formulation that we know of from the Theft Act. And so, yes, you need your menace, you need your threat, and yes, you need it combined with a demand. But the jury question, the question of mixed law and fact, is whether the demand was unwarranted rather than the threats were unwarranted. And that's because the offence is complete upon the making of the demand. That's the trigger point. In duress, it's somewhat different. Your demand leads to a contract, and the question is whether the contract is defeasible. And the classical test for that is whether the threat which was avoided by entering into the contract, the gun put to the head which didn't shoot you because you signed the contract, your house that they didn't burn down because you signed the contract, is legitimate or illegitimate, or lawful or unlawful. So the focus is slightly different. You can see probably that in the case of, once you begin to, it's possible to deal with the problems of uncertainty a little more precisely when the focus is on the legitimacy of the threat, because that's extraneous to the contract. Was that something that society would consider appropriate to threaten in order to secure your outcome? And that avoids the difficulty of unpicking the terms of the contract itself in a way. But as soon as you move to whether the demand, which then becomes a term of the contract, is made in good faith or is reasonable or not, then it seems to me that you enter into a very open-ended debate about whether it was proper to ask for £1 million or £2 million or £3 million or £4 million, or at what point does one get to a position where one can say that that is an unreasonable demand. It seems to me to be very open textured. And finally, I'd say that the lack of analogy there goes to, surely if as the respondent says, if the contract is obtained by criminal blackmail, it seems to me that the contract will be void for illegality rather than voidable for duress. But that wasn't a point which was argued before their lordships, because we were very constrained in time. So those are my thoughts, those are my insights, so much so far as they go, into how the arguments went and how the judgment might play out. So I hand back to my generous juniors acting as hosts today.
Thank you, Richard, and thanks for that discussion. I think particularly the discussion of good faith and blackmail is really interesting, and we'll wait to see how the judgment plays out. And we've had some questions come in during our webinar, and one question that's been asked is, during the hearing, did you feel there were any hints given by the panel as to their thinking?
Yeah, one, the counsel for the junior, counsel for Bankers Trust, not Bankers Trust, the second intervener, Debenture Trust, I got the name right, was seeking to argue that, look, good faith has no part to play in this. We all know that there's no overriding duty of good faith in the contract, in contract law. Anyway, the parties are in an adversarial position, therefore there's no room for good faith here. And why worry about good faith? Because anyway, the law of misrepresentation will protect the threatened party, because if somebody tells lies or misrepresents something, then the contract is defeasible for that reason. To which Professor Burrows, or Lord Burrows, said, well, surely you're going to have to persuade me that duress, a threat, is necessarily going to involve a misrepresentation, because it doesn't seem to me that the two things are necessarily combined, and you could easily have one without the other. And there wasn't really a forceful answer to that, which suggests that there is interest or appetite for a good faith type analysis, or at least a development of where we are, or let's say a rejection of the respondent's position that lawful act duress simply doesn't exist. So that was the telltale sign that I thought, the best one that there was. Everyone else was much more Sphinx-like than Professor Burrows.
Splendid, thank you, Richard. Another question which came in, someone was interested in the idea of blackmail, and they referred to a case where Lord Justice Bingham, as he there was, had been talking about blackmail and the defence that the defendant believed his conduct to be proper.
Mm.
Now, that was a case we actually looked at in due course, and you might remember, as the question foreshadows, Lord Bingham used a formulation whilst saying the test was whether the defendant believed his actions to be proper. He used the phrase about whether if someone does something which is known to be against the laws of all civilized countries, they could be found by a court actually to hold the belief. Do you think, even if the courts, even if the justices rather, follow the idea of subjective intention and subjective belief, that there's any room for that sort of backstop view, even at the margins?
Well, yeah, I mean, that's right. As I explained, we've argued for objective good faith, and we say there's good authority for that. But in the area of blackmail, where the statutory offence in the 1968 Act is more unequivocally subjective, the issue arose in a case in which, you're quite right, Lord Justice Bingham, and I forget the name of the case, said, well, it made effectively an evidential point, which is that if the supposed belief is so flagrantly in breach of the standards, norms of behavior in any civilized country, then a jury, in that case, is going to find it difficult to accept that the belief was genuine. And so rather than deploying it in that context as a point of law, whether it was objective or subjective, he was simply saying, well, as a matter of evidence, the subjective belief will be disbelieved. That was before Ivey and Genting, at a time when Gosh was reigning on dishonesty. So it wasn't quite so clear at that point that honesty had an objective element to it. Now, there's no doubt that the way that the Theft Act formulates the test of blackmail is subjective, and that was the express intention behind the change in the law. But I suppose it's to be implied that a belief held subjectively is an honest belief, and as soon as you admit that, then you're into the shading into the idea of objective assessment. Now, whether that's different from what Lord Justice Bingham was talking about in that case as a purely evidential matter or as a matter of law is perhaps a nicety. But even in the area of blackmail, I think that the courts should be deciding these things by reference to objective standards, what honest, decent, reasonable people believe to be honest. So those are my thoughts.
That's great, Richard.
Thanks, Richard. We've had one more question in the chat, particularly on good faith, and I think this will be quite an interesting point to come out in the judgment. Luke Harrison has asked, do you think that the law of good faith has room to develop in other types of relationships to the special classes of relationships identified in the UTB v Sheffield United case? In particular, do you think it's more likely to develop where there are foreign counterparties from jurisdictions with codified rules of good faith? So we're looking into the development of good faith within the English law system.
Wow, big question. I'm afraid I don't know the case that you're referring to off the top of my head. I certainly work with a number of European lawyers, and their mindset, the fact of the existence of a general duty of good faith definitely affects their mindset. It's the first argument that they reach for. Breach of duty of good faith, that's number one. The common law, as a matter of policy, has set its face against a generalized duty of good faith on the basis that commercial parties, international commercial parties, don't want it. They want certainty over the equities of any particular case. And that's probably true as far as international corporates are concerned. It may be less true as far as the consumer is concerned, but then perhaps the balance is restruck by legislation which shifts us away from freedom of contract. But certainly, I mean, you could see it in the submissions in the Supreme Court here, is that the reflex of an English lawyer is simply to say, good faith, bad thing. We've all decided it's a bad thing, stay away. And that is really an argument which is your first run argument in relation to somebody trying to imply a duty of good faith. But people very often go beyond that and start thinking about, well, if a duty of good faith exists, what does it mean? And I think that's an area where we should see development, even if we're not having some paradigm shift in, good faith should be everywhere. As soon as you start thinking more precisely about what a duty of good faith means, it seems to me that courts will be more ready to imply and develop it in particular circumstances, like, for example, the exercise of discretion in good faith in accordance to the purpose for which it was granted, which is developed out of public law, developed out of employment law, which is becoming a really very powerful tool in commercial context generally. But that depends upon its being neatly circumscribed. And, so the more you define good faith, which hasn't really been done, it was clear from the submissions in the Supreme Court. It's not really clear what people think they mean when they say it. But with more precision, it'll become a more useful instrument, I think. That's the
Thanks,
best
Richard. And I
answer
think
I
some
have.
of the cases you touched upon earlier, Yamseng and Bates v Post Office, we can see that there is definitely is still a developing area.
Well, interesting. All of those cases are quite new. They're all in the last 5 years. You know, they're not. There's not a long line of authority on what good faith actually means. There's a good case called Woolgar States from I think the 70s. Lord Denning saying it means honestly and without ulterior motive. But which is a lovely, crisp and clear formulation. But that's specifically in relation to a statutory power to enfranchise freeholds, I think it is. But you have to look quite a long way. You know, they're pretty few and far between to get something as pithy and lucid as that.
And there is actually, if I may say, there's an unknowable Brexit wrinkle to this as well. Because when you identify some of those areas, Richard, where those points come up, they're often because the United Kingdom government has had to transpose European law into this legal order.
Exactly.
Doing that, the judiciary became more familiar and in turn more comfortable and perhaps even more receptive to some of these concepts.
Yeah, exactly.
And now, with the very limited take into account role with respect of decisions of the Court of Justice, it can't be predicted with certainty, it seems to me, the attitude the United Kingdom judges, whether that's England and Wales, whether that's Scotland, whether that's Northern Ireland, are going to take to these concepts, and whether we'll want to make roast beef versions of them.
Yeah, it's unknowable at this stage, isn't it? We've just jumped into a whole new world, and we're going to have to see what the judges make of it. I can see. I think they, I think they would. They're likely to take those kind of authorities, European authorities, in the same way they would a Canadian or an Australian authority as persuasive. I think it's in their natural instinct to do so, and it's entirely rational to do so. It would be as a result of a deliberate change of policy that they want to move in a different direction, I think. But that's speculation, I'm afraid.
Well, unless there are any further questions, and certainly we'll give anyone a moment to ask one if they wish, then all the really that's left for us to do is to thank you for your attendance. Thank you for joining. We hope you've found it valuable, and certainly we really appreciate the fact that you've taken some time to come along today.